Usually, when we think about the machinery that keeps society running, we picture like physical things.
Right, like power grids or bridges.
Exactly. Power grids humming, bridges carrying thousands of cars, massive water treatment plants.
And if those fail, it's just immediate, visible chaos.
Total chaos. But there is this whole other kind of machinery, an entirely invisible one, that holds everything together just as critically. I mean, without it, society just descends into literal private vengeance.
Yeah, it's the mechanism that literally stops us from, taking a baseball bat to our neighbor's car when a dispute comes up.
Right.
It's just the sheer willpower of a civilization deciding, hey, we're going to settle things with paper and debate rather than physical force.
Which is honestly wild when you think about it. So welcome to this deep dive. Today, we are looking at the intricate blueprint of how that invisible machinery actually operates for you.
And specifically, we're diving into the Brazilian civil procedural law system.
Yes, focusing on their 2015 Civil Procedure Code. And our mission today, just to be clear, isn't to just flip through some dry rulebook.
No, definitely not.
We're decoding how a modern state handles human conflict. We're going to explore the profound philosophy of how you demand justice, how the state protects itself from being absolutely overwhelmed by frivolous demands, and how the law is radically mutating right now to fix massive societal failures.
It's a huge topic.
It really is. So, okay, let's unpack this.
Well, civil procedure is basically the DNA of a civilized society's promise to you.
Yeah.
Like the state took away your right to exact revenge.
Right. No more baseball bets.
Exactly. And in exchange, it provided a structured, state-sponsored system for resolution. But before we can even look at how people fight in court, we have to understand the arena itself.
We have to define what a court case actually is.
Yes. And looking at the structure of the 2015 code, there is a very deliberate, almost philosophical distinction made between the process.
Just processo in Portuguese, right?
Right, processo, and the procedure, which is the procedimento.
And I feel like to most people, those just sound like totally interchangeable synonyms.
Oh, they do, but they are completely distinct concepts. The process is, it's abstract. It is the actual public law relationship between the judge and the parties involved.
Okay, so a relationship.
Yeah, a dynamic living web of rights and obligations aimed at resolving a dispute. Procedure, on the other hand, is the literal external step-by-step choreography.
So the physical actions.
Exactly. It's the modus faciendi, the physical sequence of acts, filing the papers, stamping the documents that, make up the case.
Okay, think of it like going to a restaurant.
I like this. Go on.
The process is the social and legal contract, right?
Yeah.
It's the relationship between you, the waiter, and the chef, built on the mutual understanding that you're going to get fed and they're going to get paid.
That's a great way to put it.
And then the procedure is just the physical manifestation of that, handing out the menus, writing down the order, physically carrying the food to your table.
That restaurant analogy captures the exact dynamic. The procedure is just the outward manifestation of that deeper binding relationship.
But wasn't that whole relationship idea heavily debated?
Or absolutely, for a long time. There was this prominent Italian jurist named Fazzolari, and he pushed back against this entirely.
What was his issue with it?
Well, he argued that the process isn't a relationship at all. He claimed it is just a normative structure.
Like a set of rules.
Yeah, in his view, a lawsuit was more like a board game. Just a cold set of rules dictating how pieces move across a board with no inherent connection between the players and the referee.
Wow, that's a completely mechanical view of justice.
It is. But Brazilian legal doctrine predominantly rejects Fazzolari's mechanical view. They stick to the traditional view that the process is fundamentally a living, breathing relationship.
So it's not just a judge sitting up high and barking orders.
Not at all. It is a cooperative, multipolar dialogue. The parties have powers and duties, and so does the judge.
Meaning the judge can't just act like a dictator, right? They're bound by the relationship, too.
Exactly. And the primary example of this is the principle of non-surprise.
Non-surprise.
Yeah, a judge cannot suddenly issue a decision based on a legal theory or a piece of evidence that the parties haven't even had the chance to debate.
Oh, I see.
Every single participant in that courtroom has to contribute to the intellectual formation of the final judgment.
So you can't just pull a rabbit out of a hat at the verdict. Everyone has to see the rabbit first.
Perfectly said.
Okay, so if the process is this binding cooperative relationship, how do you force the state to enter into that relationship with you in the first place? Like if my neighbor smashes my fence, how do I compel this massive bureaucratic machine to even care?
That introduces the evolution of the right of action. And this is where the philosophy of law gets incredibly deep.
I'm ready.
If we rewind to Roman times, and even up through the 19th century with brilliant jurists like Sevigny,
Right.
the action was just considered a reflex of your material right.
Meaning, if I didn't legally own the cow, I simply didn't have the action to go to court and get the cow back.
Exactly. The action and the right to the cow were treated as the exact same thing.
Yeah.
In that old view, you couldn't separate the two.
But that changed, obviously.
It did. In the mid-19th century, there was a famous debate between two German scholars, Windscheid and Mother, and that shattered the assumption.
What did they figure out?
They proved mathematically and philosophically that the right of action is autonomous. It is entirely separate from the substantive right you are arguing about.
Okay, so it's a separate thing.
Yes, action is an abstract, public right directed at the state itself, not at your opponent.
Wait, let me throw an absurd scenario at you to see how autonomous this really is.
Sure, go for it.
Say I walk into a courthouse and I formally sue someone, demanding the inheritance of a person who is, like, currently alive and well.
Okay, a completely ridiculous premise.
Totally ridiculous. Am I still successfully exercising my right of action?
You actually are.
Wait, really?
Yes. You are exercising your public right to demand the state's attention. The state fulfills its constitutional duty to you by taking your case, evaluating it, and rendering a judgment.
Even if the judgment is just, you're an idiot.
Exactly. In your absurd inheritance example, that judgment will be to throw your case out immediately and likely penalize you for wasting everyone's time.
Yeah.
But you still possessed and utilized the right of action.
That is fascinating.
Right. This autonomous right is the ultimate proof of the state's monopoly on justice. Because the state outlawed your ability to settle things with violence, it owes you an answer when you formally provoke it.
What?
It owes you a resolution, regardless of whether your claim is brilliant or, completely detached from reality.
Okay, but if the state owes an answer for literally anything, even a living person's inheritance, how does the entire judicial system avoid collapsing under the sheer weight of millions of absurd, irrelevant, or vindictive demands?
Good question. The state builds a highly sophisticated series of procedural gatekeepers.
Gatekeepers, okay.
Yeah, the system has to filter out the noise before it expends its most valuable resource, which is a judge's time and energy to evaluate the actual merits of a conflict.
Makes sense.
Under the 2015 code, which adopted the Italian jurist Enrico Tullio-Liebman's eclectic theory, you have to pass specific, rigorous tests. They're called the conditions of action.
Let's look closely at those conditions, because the primary ones, looking at our sources, are interest and legitimacy.
Right. And interest isn't just about being, intellectually curious about a legal outcome.
Right. It requires two distinct elements, necessity and adequacy.
Exactly.
Necessity means you genuinely need the state's intervention, like you've exhausted your options, or the law requires a judge's signature to proceed.
And adequacy means you picked the right legal tool for the job.
Right. So you can't use possessory action to kick out a tenant who stopped paying rent. The law demands you use a specific eviction action.
Spot on. You might have brought a very real problem to the courthouse. But if you use the wrong door to get inside, the gatekeepers will just throw the case out before a judge ever even looks at the lease agreement.
Okay, so that's interest. What about legitimacy?
Well, you must be the titular owner of the right, fighting the specific person who actually resists it.
So no fighting your neighbor's battles for them.
Exactly. You cannot go to court claiming someone else's right in your own name. Now, there are exceptions where the law specifically allows extraordinary legitimation, like a labor union suing on behalf of its workers. But generally, you have to fight your own battles.
Now, I noticed it used to be that the law required a third condition called legal possibility of the request, but the 2015 code completely dropped it.
They did, yeah.
Why abandon a rule that seems to make so much sense?
Well, the modern philosophical shift determined that legal possibility wasn't a gatekeeping issue at all.
How so?
Think about it. If you ask the court to enforce a gambling debt in a country where gambling is illegal, your request is legally impossible, right?
Yeah.
But discovering the impossibility requires the judge to look at the law and make a ruling on the merits of the case. So it was absorbed into the final judgment, rather than acting as a gatekeeper.
Oh, I see. So the gatekeepers focus solely on whether you have the right standing and the right tool.
Exactly. And beyond those conditions, the system also intensely scrutinizes capacity.
Capacity, meaning who is legally permitted to stand in that courtroom and speak for themselves.
Right.
So if capacity is about who is allowed in the room, How does the system handle shared rights? Like, imagine you and your spouse own a home.
Okay, classic scenario.
Right. Someone encroaches on your property line and you want to file a lawsuit to protect the land. But your spouse, out of pure spite or stubbornness, completely refuses to get involved or sign the paperwork. Are you just legally paralyzed?
That's a great question. And you are describing the exact friction point addressed by Article 73 of the Code.
Oh, there's a specific rule for that.
Yes. The general rule is that married couples cannot sue someone regarding real estate without their spouse's formal consent.
Unless they are married under absolute separation of property, right?
Exactly. It's a protective measure to ensure one spouse doesn't unilaterally risk the family's core assets in some reckless lawsuit.
Right, but what about the spiteful spouse?
Well, the law actively anticipates human pettiness. If a spouse is withholding consent unjustly or maliciously, a judge can step in and judicially supply the missing consent.
That is a massive relief.
Yeah, the system won't allow you to be paralyzed by an unreasonable partner.
Another profound shift in capacity that we saw in the sources came with the 2015 statute of the person with disabilities.
Yes, this was honestly a watershed moment for legal dignity.
Because previously, severe mental illness made someone absolutely incapacitated in the eyes of the law, right?
Right. It stripped them of nearly all independent legal agency. But the 2015 statute radically restricted absolute incapacity solely to minors under 16.
Wow, just kids under 16.
Yeah. Everyone else, including adults with severe mental illnesses, is now considered relatively incapacitated.
Which completely changes the dynamic.
Totally. They are no longer completely spoken for. They are assisted.
Yeah.
It preserves a vital layer of their dignity and their agency within that public relationship we call a process.
That's amazing. Okay, so the gatekeepers do their job. They filter out the people who lack capacity, the people who don't have a genuine interest, the people who brought a hammer to turn a screw.
Exactly. The system ensures only validly structured cases survive.
But what happens when the exact same valid dispute slips through two different doors of the courthouse at the same time?
Oh man, that is the ultimate nightmare for any judicial system. The nightmare of contradictory judgments.
Right, because imagine a reality where Judge A looks at a contract and says you own the property, and Judge B looks at the exact same contract on the same day and says you don't.
The entire illusion of legal security shatters instantly.
Yeah.
So to prevent this, the law deploys two automated fail-safes, connection and continence, or connexec and continency.
Let's break those down. Connection is when two cases share either the same request or the same cause of action. Think of like a landlord who files an eviction for unpaid rent in one court. And meanwhile, the terrified tenant sprints to a different court and files a separate case trying to formally deposit that exact rent money to avoid being kicked out.
They are two sides of the exact same coin.
Right.
If you let them proceed in isolation, one judge might sign an order to drag the tenant out onto the street, while the other judge signs an order accepting the rent and validating the lease.
Total disaster.
Okay.
And then there is continence. This happens when one case entirely swallows another because the request is geographically or financially broader.
Give me an example.
Let's say I sue you in January for missing your December payment.
Okay.
But then a month later, I file a massive lawsuit against you in a different court for the entire total debt spanning 3 years, which obviously includes that single December payment.
I see. The second case physically contains the first one.
Exactly.
So when either connection or continence triggers, the system demands an immediate merger. The duplicate cases are ripped out of their respective courts and pulled together.
So they get judged by the same person.
Yes. They must be judged simultaneously by the prevented judge.
And prevented just meaning whichever judge received the case first, right?
Exactly. The first judge to receive the distribution becomes the gravitational center. All related cases are pulled into their orbit.
That makes a lot of sense.
But here is the mechanical secret of how this actually works. A judge cannot simply eyeball 10,000 files to spot overlaps.
Right. No human could do that.
The system requires a mathematical backbone. And this is why the code relies so heavily on the value of the cause.
Value of the cause. Right. Every single case must have a monetary value attached to it, even if the dispute is purely moral.
It acts as the metadata of the legal system. A moral dispute without a dollar amount is invisible to a sorting algorithm.
So they have to assign a dollar value to everything.
By forcing every action to have a financial anchor, the system can organize, index, and merge cases. Like, if you are suing for alimony, the law artificially sets the value of the cause at 12 months of those payments. If you are suing for eviction, it assigns a value of 12 months of rent.
It creates a measurable weight for every single dispute.
Exactly.
So really, the judicial system operates like a giant sorting algorithm, constantly scanning the metadata to avoid the embarrassment of giving two different answers to the exact same problem.
And it goes far beyond embarrassment, you know. It is the bedrock of legal security.
Because consistency matters.
Right. A justice system that contradicts itself ceases to be a system of justice and becomes a lottery. And if outcomes are totally random depending on which courtroom you happen to walk into, the public loses all faith in the state's monopoly on dispute resolution.
And when that faith vanishes, society starts reaching for those baseball bats again.
Exactly. We're back to private vengeance.
Okay, so algorithmic sorting works perfectly when you have two individuals fighting over a measurable debt, a landlord versus a tenant, a creditor versus a debtor. But what happens when the math breaks down?
What do you mean?
What happens when a dispute isn't A versus B, but an entire society versus a failing public institution?
Well, now we are entering the law's modern frontier. Traditional A versus B dispute resolution is fundamentally unequipped to handle massive societal failures.
And looking at our sources, this frontier has two distinct faces, right?
It does. The first is predatory litigation. This is the dark side of modern mass consumer society.
Yeah, automated, repetitive lawsuits designed to actively choke the judicial system.
It's crazy. Thousands of identical claims flooding the courts, often orchestrated by bad actors hoping to force corporations or the state into mass settlements just to clear the administrative backlog.
But how does a human judge fight back against a mechanized, automated flood of lawsuits?
By automating the court's response.
Oh, fighting fire with fire.
Exactly.
Yeah.
The judiciary utilizes binding precedents and repetitive case resolution systems.
So instead of judging 10,000 identical airline delay lawsuits individually,
Right. The highest courts take one representative case, make a definitive philosophical ruling, and apply it instantly across the entire grid. It is the only way the machine survives the flood.
wow. But the second face of this modern frontier is much more ambitious. It is the structural process, or processo estructural.
Yes.
And this feels like the absolute pinnacle of modern civil procedure. We aren't talking about unpaid rent anymore. We are talking about forcing a government to build schools or completely overhaul an unconstitutional prison system.
Or remediate a catastrophic environmental disaster spanning multiple cities. The structural process requires a total paradigm shift in how we view the role of a judge.
The sources mention a landmark Supreme Court case in Brazil involving a deeply flawed public hospital in Rio de Janeiro to illustrate this.
Yeah, that hospital was failing on every conceivable metric. It was lacking staff, lacking basic medical equipment, and it was structurally unsafe.
And if a traditional judge looked at a failing hospital, they might just issue a binary order saying, fix the hospital in 30 days or the state pays a daily fine.
Which is totally impossible. You can't magically summon neurosurgeons, rewrite municipal budgets, and build new surgical wings in 30 days.
Right. A traditional rigid sentence would just crash against the reality of public administration and fail instantly.
Exactly. But the structural process recognizes this limitation. Instead of a binary order, it demands a highly flexible, multipolar, cooperative approach.
So what does the judge do?
The judge sheds the role of an oracle handing down a verdict and acts almost as a crisis manager.
Oh, manager.
Yeah, they set a non-negotiable goal, like bringing the hospital up to basic constitutional health standards, and then they require the government to present a long-term adaptable plan to achieve it.
So the judge might oversee the reallocation of resources or the integration of NGOs, maybe staging the improvements over a span of years.
Right, the process stays open and adapts to reality.
But this creates massive political tension. I mean, critics immediately label this judicial activism.
They do, yes.
And look, we aren't taking a side here, but there is a strong argument that judges aren't elected to run hospitals or manage state budgets. Isn't this the judicial branch, violently usurping the executive branch?
Well, it is one of the most fiercely debated topics in constitutional law globally. The critics have a deeply valid point. Allocating budgets and managing healthcare infrastructure is the strict constitutional domain of the executive and legislative branches.
So the judiciary stepping into that arena definitely strains the separation of powers.
It absolutely does. However, the counter-argument the sources highlight is equally profound. When the state severely and chronically violates fundamental human rights like the right to life and health in that Rio hospital, the judiciary simply cannot omit itself.
Because a constitution is worthless if the state just lets people die in a broken hospital while citing administrative red tape.
Precisely. In the structural process, the judiciary is not trying to act as a dictator. It acts as an authorized intermediary.
That's a good way to put it.
It forces an institutional dialogue that is broken down. It compels the other branches to actually do their jobs, ensuring that the promises written in the Constitution are manifested in reality.
It's the ultimate evolution of that process we defined at the very beginning.
It really is. It expands from a structured relationship between two fighting neighbors into a structured relationship between the branches of government itself, trying to heal a failing public institution.
It is incredible to look at the journey we've taken through this invisible machinery today. I mean, we started by dismantling the idea that a lawsuit is just a street fight in a courtroom, revealing it as a highly structured, cooperative public relationship.
Yeah, that shift in perspective is so important.
And we explored the philosophical breakthrough that gives you the autonomous right to demand an answer from the state, regardless of how absurd your demand might be.
Even the living person's inheritance.
Right. And then we examined the rigorous gatekeepers of interest, legitimacy, and capacity that protect the system from collapse. And how the courts use mathematical values to merge cases and avoid the nightmare of contradictory rulings.
It's a massive, complex system.
It is. And finally, we saw how the law is radically stretching its own traditional boundaries through the structural process to fix massive public policies and protect human rights.
It is a remarkable system, constantly adapting to the impossible complexities of human behavior. And I want to leave you with a final thought to mull over.
Well, let's hear it.
For centuries, the legal process was fundamentally backwards looking. It was obsessed with figuring out what happened in the past and compensating for it.
Like who broke the contract yesterday or who caused the crash last week?
Exactly. But with the rise of the structural process, courts are increasingly looking forward. They are trying to actively engineer future social realities. So if the courtroom is no longer just a place to settle old debts, but a place to design future public policy, what does that mean for the role of the everyday citizen in shaping their own democracy?
That invisible machinery holding back the chaos, it is not just maintaining the status quo anymore. It's actively building the future. Something to think about. Thanks for joining us on this deep dive.